3D printing and 3D scanning are going to become mainstream technologies soon. Let's see how do they affect IP rights. If we look back to the past 30 years, we see the result of the clash between IP rights and new technology, and in particular digital technology. We may be more or less happy of the present situation, of the result of this clash, but for sure we may learn something from the past. We have a couple of lessons that we may try to get from what happened. The first lesson is about the function of IP rights. They are probably not well suited to regulate behaviors and acts which are carried out by private physical individuals. The second lesson is related to patents. They were put aside at the very beginning of the digital revolution, but this was probably a short-sighted choice if we look at the role they presently play in this field. We will have a chance to apply these lessons in a revolution which is now coming, which is the revolution brought by 3D printing and 3D scanning technology. These technologies are becoming mainstream, and a lot of important players are starting to develop new machines, new apparatuses, new invention, and we will probably face a revolution which will be not so different from the revolution I mentioned before. In this scenario, the IP rights will face similar challenges, and it is important to try to address these kind of issues in the correct manner from the very beginning. We may try to think about some basic principles. The first one is that physical objects will become some instances of digital information, and we should focus the protection on the digital information. And when framing this protection, we will need to take into account that digital information can be copied and cannot be controlled in a networked environment like the present internet. So a correct level of protection must be devised. Correct level of protection means also taking into account the need of the individuals, of the private individuals, which activity should at some extent be exempted from sanctions. Now, correct level of protection means that this protection should not hinder technical innovation, and this means probably that patents should be the correct IP right to invoke to give this kind of protection. And the correct level of protection means also that we should take into account that individual acts could not be subject to sanctions, or should find some sort of exemption. The last principle is the fact that in this revolution new markets and new players will emerge, and IP rights should nurture them and help them to grow. We are already providing assistance to clients in connection with these issues, even if they are brand new, and so we will be in the position to provide you with updates and development on this revolution, and of course we will report them here on Lawyers Monday.